So I have an update in the forced reset trigger lawsuit against the ATF, and currently the Fifth Circuit is set to rule on this issue. But now multiple anti-gun states are trying to get involved in this case and become named defendants and actually protect the FRT ban. So let's talk about what is happening. Now, really quick before we jump into this video, I just wanted to mention that looking at some of my analytics, about 60% of all my viewers are actually not subscribed to the channel. So if you want to support the channel for free, a free way to do that is simply subscribing. Also, click the notification bell, turn on all notifications, because that helps to ensure that YouTube will actually send you these videos. As I mentioned in the intro, in this video, I have some very important updates in the battle against the ATF and the restrictions on FRT triggers, or force reset triggers. You may recall that earlier this year, we received some big news out of a federal district court, a lower court judge, Judge Reed O'Connor, who granted NAGR and Rare Breed a motion for summary judgment. That means that he reached a final decision striking down the ATF's FRT restrictions entirely, and he found that those actions were unlawful and also went beyond the ATF's authority. That decision came in the case called NAGR versus Garland. Now, in response to that ruling, the ATF has appealed to the Fifth Circuit, and they're asking for the Fifth Circuit to reverse that nationwide vacatur of that rule, and they want the Fifth Circuit there to allow the ATF to restrict these triggers. There was also a period there where the ATF wanted Judge O'Connor to extend out some of the requirements that he put on them, where they would have to give notice to everyone and then also actually give back some of the confiscated FRT triggers. And Judge O'Connor ultimately denied a stay on his own decision, but he did give the ATF a little bit more time to comply with the relief that was ordered in that decision. Now, this case was recently argued in front of the Fifth Circuit Court of Appeals, and after that, multiple anti-gun states have asked the Fifth Circuit to allow them to intervene in the case as new named defendants. So they want to be parties in this lawsuit so that they can defend the FRT rule. However, that attempt just epically failed. The states that sought to intervene in this case as defendants were New Jersey, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maryland, Massachusetts, Michigan, Minnesota, Nevada, North Carolina, Oregon, Rhode Island, Vermont, and Washington. Now, this whole case arises out of the unlawful action of the ATF trying to change the definition of what a machine gun is in the GCA and the NFA, and they want that definition to include forced reset triggers. So back in July 2021, the ATF sent out a cease and desist letter to companies like Rare Breed Triggers. Now, in that letter, the ATF claimed that the FRT triggers here, sold by Rare Breed and created by Rare Breed, actually met the definition of a machine gun under the NFA and GCA. Rare Breed then, in response to that, filed multiple lawsuits, but most recently, Rare Breed partnered with NAGR, a 2A organization, to file a lawsuit against the ATF in the Northern District of Texas. And the case was assigned to Judge Reed O'Connor, who is an amazing judge responsible for a lot of wins that we've got against the ATF. And on review, Judge O'Connor again sided with us and struck down the entire ATF restrictions on FRTs. Now, in reaching his decision, Judge O'Connor again relied on the analysis in another case called Cargill, which was recently ruled on by the Supreme Court in a 6-3 decision. Judge O'Connor stated in his decision that function and pull are not synonymous. The former is based on a mechanical perspective, whereas the latter is based on the shooter's perspective. He went on to state that applying the guidance from Cargill, FRTs do not fire multiple rounds with a single function of the trigger and thus do not qualify as machine guns. So we all knew that the Cargill decision would have very important trickle-down impacts on a lot of other ATF interpretation cases, and now we saw that play out directly when it came to FRTs. Now, as of right now, there is still an appeal going on at the Fifth Circuit level. Fifth Circuit has heard oral arguments between the ATF and the plaintiffs here, and essentially what also is happening is the ATF is trying to get Judge O'Connor's decision reversed. The Fifth Circuit recently, like I mentioned, held oral arguments, and during the arguments, the ATF claimed that the judge here, Judge O'Connor, got his analysis wrong and that the ATF has considered these types of devices as machine guns for over 50 years. So in their briefs, the ATF argued that the court was mistaken in all respects. As noted, ATF treatment of devices of this type as machine guns long predates the 2018 bump stock rule. The Supreme Court's application of the machine gun definition in Cargill reinforces rather than undermines the longstanding view of the ATF. So that is what the ATF is claiming. The ATF is claiming that the Supreme Court's recent Cargill decision actually supports them treating FRTs as machine guns and should not be used to strike down this FRT rule. The ATF is trying to distinguish the action caused by a bump stock from the trigger pull mechanism involved in FRTs, and the ATF tries very hard to claim that Cargill and that decision should not have impacted the decision here at all, and Judge O'Connor should not have relied on Cargill. In response, NAGR and Rare Breed argue that the Cargill interpretation of the statutory language is actually very fatal to the federal government's arguments and is actually controlling in this case. Now, out of the oral arguments in the Fifth Circuit, we listened to those and I've done a breakdown video of those arguments. It sounded like that maybe we would get a 2-to-1 win in our favor. And it appears that some anti-gun states felt the very same way. And as a result, they are now attempting to intervene in this case as new named parties. They want to join as defendants so that they can defend this FRT ban. However, on review, the Fifth Circuit outright rejected that attempt of these anti-gun states to intervene as defendants. The original order of the Fifth Circuit states that it is ordered that the opposed motion of the states to intervene as defendants, appellant is denied. Movements may seek to participate as amici. So the Fifth Circuit said, no, we're not going to let you become defendants in this case. If you want to be involved, file an amicus brief in support of the ATF. However, the states did not take that very well. They didn't like hearing no, I guess, and they decided to file a renewed reconsideration motion so that they can once again bring up the issue of them wanting to intervene as defendants. Essentially, they filed a request to intervene once again, saying, are you really sure, Fifth Circuit, that we can't join as a defendant? In the motion for reconsideration to intervene, the states argue that moving states asked this court to reconsider its denial of the motion to intervene. The reason is simple. Participation as amici fails to provide the states with the tools necessary to protect their interests. In their opening motion, moving states laid out the basis of their intervention motion. The resolution of this litigation threatens significant proprietary and quasi-sovereign state interests, and no existing party is adequate to defend those interests. In essence, the states argue that if the FRT rule is struck down by the Fifth Circuit, there will be so much harm to the states and their residents, and because of that, they believe they should be allowed to defend the FRT rule. But once again, the Fifth Circuit rejected their motion to reconsider, and they're not allowing them to intervene as defendants. The Fifth Circuit told the states for a second time, no, you will not be allowed to participate in this case as defendants. You will not be allowed to intervene as a party. And if you want to help the ATF, once again, file an amicus brief. So that's actually really good news. The Fifth Circuit rejected the anti-gun states' attempt to get involved in this case, to help the ATF and become defendants in this lawsuit to protect the FRT ban. Now we will wait to see how the Fifth Circuit rules on this issue. And keep in mind, like I mentioned, the oral arguments have already taken place in this case. And in my opinion, it sounded like maybe we would get a win, maybe a 2-to-1 win in our favor, again, striking down the FRT ban and finding that the Cargill 6-3 decision by the Supreme Court dealing with bump stocks does control also on this issue of FRTs. So that's where the FRT challenge currently stands. Anti-gun states tried to get involved, but they were rejected by the Fifth Circuit, which again is a good sign. So as we get more information, I will let you guys know. If you guys like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, the station was built by ARM scholars, and the station will be maintained by ARM scholars.